Good morning, everyone, and happy Tuesday. And if it's Tuesday, you know that means that it is Tipsy Tuesday, which means another trademark tip. My name is Nicole Gaither. I'm the founder and managing attorney of Creativa IP Law, and thank you for being with me today. Today's topic is going to be on the fact that there are actually two U.S. trademark registers. Yes, within the USPTO, there are two registers that your trademark may appear on. One is known as the principal register, and one is known as supplemental register. And we're going to kind of go into detail about them. And of course, I'm going to show you all some visuals just so you can get an idea of what the differences are as I explain them. So if your mark is one that is unique, distinctive, then it's more than likely going to appear if you are, if it does get registered, it will more than likely appear on the principal register. If you have a mark that's more descriptive, kind of close to describing the goods and services that you're offering, then more than likely, if it is approved for registration, then it might appear on the supplemental register. And there's some benefits to, of course, there are more benefits to being on the principal register. I don't want to call it the best register, it's better. And then, of course, you have the supplemental, which is better than no trademark registration. So there are some, of course, there are higher benefits to being on the principal. There are some benefits, of course, being on supplemental versus like not having anything at all. But we will talk about those in detail. So if you're on the principal register, that means that your trademark, like I said, has been deemed unique, distinctive, that, and then, with that registration, you presume to be the owner of that trademark. So let's say, you end up in court, either you've sued somebody or somebody has sued you, then since you are the presumed owner of that trademark, it's up to that other party to prove otherwise. So like they have to bring evidence to show that you don't own it because you are on the principal register and you have that registration, you're already presumed to be the owner in all 50 states. So that's, a really good plus to that. It's on another party for you to prove it. Likewise, so with the supplemental register, and I guess otherwise, really, it's up to you to have to prove that you're the valid owner of that trademark. And so the burden's on you to prove that you own that mark. So those are, that's one of the bigger differences. With both registers, you get to use the circle R. So you still have that circle R behind your trademark. So that's, benefits of both versus not having anything at all. But of course, like I said, we're going to go into a nice little PowerPoint so I can show you all. So without further ado, let me do a screen share. And okay, so like I said, there are two types of U.S. trademark registers within the USPTO. There's the principal and the supplemental. And again, the importance is based on how strong your brand name is. So if you have like the coined or fanciful marks, which is ones, the ones where you've made up a name, or like you've made up the name. If it's arbitrary, which means that you have a word that's in the English language, but you've applied it to something that's not really, related to it. So think like Apple computers. If it's suggestive, which kind of, gives you an idea of what, like you got to use your imagination to figure out what the goods or services are. If it's descriptive, which, this is kind of, when we're moving into the descriptive territory, this is where we're going into possible appearance on supplemental register. And again, generic trademarks are not granted trademark rights because they are not eligible for registration. So if you have any questions about this, I did a video on this last week and I will put a link in with this video so you can, go to it and see my detailed definition and explanation of the differences between the strongest to weakest marks. All right, so the differences between the two registers, and like I said, I kind of touched on this. The principal register protects distinctive trademarks, so these are like the unique ones. They're distinctive. Those are the top three that we kind of talked about: the coined and fanciful, the arbitrary, suggestive. Supplemental protects only non-distinctive trademarks, so that would be like your descriptive marks, ones where you are going to get registration, but you're going to appear on the supplemental register because your mark is not deemed very distinctive or unique. With the principal register, you have the presumption of ownership, and it gives constructive notice so that infringers can't say like, well, I didn't know about it. Well, you should have, and I don't have to go into all this explanation for you. Like, you can't use the good faith defense, like, oh, I just, oops, didn't know. Supplemental, on the other hand, there's no presumption of ownership. Even though you do own it, you have to prove that you own it. And if an infringer actually tries to use your mark, there's no way that they can use the defense to saying that they didn't know. Like, they would be able to use that defense. All right. With the principal register, at some point after 5 years, your mark can become what's called incontestable, which means that, after 5 years, no one can come back and say, hey, I already was using that mark and you can't use it like I was using it before you. Because once it becomes incontestable, they can't challenge it anymore. So that's something that comes after 5 years of being on the principal register, using your mark and putting your mark in use, using it consistently for 5 years. However, supplemental, on the other hand, of course, it cannot be incontestable. As long as it appears on the supplemental register, someone can challenge it. So like that means, after year 1, year 3, year 5, year 10, year 20, if somebody just, sees, they decide, 20 years after they have been using this mark that they finally want to apply for a registration for, and they see that your mark is there, they can challenge your mark if it's still on the supplemental register after, that period of time. And there is a way that your mark, if it appears on a supplemental register, may eventually be able to move to the principal register after a certain period of time. It's generally after you've been able to prove that your mark has acquired distinctiveness, which means that people are familiar with your mark, they're familiar with the products and services that you offer, and it's well known in the market. So there is a possibility that if you are originally placed on supplemental register, that you can reapply with your mark and move and have your mark eventually get approved for the principal register. With the principal register, you can record your trademark with the U.S. Customs. So like, let's say you have goods and services, and let's say it's going to be goods, sorry. So let's say that you have goods, like maybe you make bags, purses, things like that, things that people might counterfeit. So if you register with the customs office, if someone tries to import an item that is a counterfeit and it's infringing on your mark, the U.S. Customs Service will stop it from coming over the border. The supplemental, you cannot record that with the U.S. Customs, so keep that in mind. Principal register, you can actually, you get standing to, you have like the Madrid Protocol allows you to actually file an international application using your U.S. trademark application. So while your U.S. trademark application is pending through the process, you can file through the Madrid Protocol an international application, and it gives you that priority date from your U.S. application filing date. With a supplemental register, you cannot file the Madrid Protocol based on your mark. It's not to say that you can't file an international application. It just means that you cannot use the Madrid Protocol, and that whatever filing date that you use for your international mark, that's the date that your international mark was filed. You can actually, with the principal register, you can file the intent to use application. Those are the applications where you can reserve the name that you plan on using before you even start using it. So this is kind of like that reservation system. With supplemental register, you cannot file something that's an intent to use. You must already be using the mark in commerce. So those are some of the bigger differences between the two registers. And then, of course, like I mentioned, there are the advantages of being on the principal register, and then there are also the advantages of being a supplemental versus not having any registration. So you can still file a trademark infringement lawsuit in federal court, just like a principal registered mark. Third parties cannot register a confusingly similar trademark on the principal or supplemental register because your mark still appears in the database. So the USPTO will, if someone tries to file a mark that's similar to yours and your mark is on the supplemental register, they won't allow that mark to go forward because you have a trademark already registered. You can still use a Circle R, like I said. And then, as I mentioned, after the mark has been used and registered for, and this is usually thrown out like 5 consecutive years, you can reapply on the principal register. You would have to prove, of course, that your mark has acquired distinctiveness, that people are familiar with it. So generally, that's kind of what people say, like that's the 5 years. It might be, less time than that. It might be more, but you have to prove that people are familiar with your mark, they're familiar with your products and services, and they associate your mark with those products and services. And that is it. So that kind of explains pretty much what the differences are between the two US trademark registers. And of course, like I said, principal is reserved for unique trademarks. You're the presumed owner. The more your trademark describes your product or service, like, if it's more descriptive, the less likely you will be on the principal register. So think of like if you use something like super, great, terrific, sweet, tasty, if those are how you're, applying that for your mark, be aware that it might be deemed descriptive. And again, with the supplemental, there's no presumption of federal ownership. So if you do sue someone for trademark infringement, you have to prove that people know that your brand, they know your products, and associate your trademark with those products. So it's the burden is on you to prove that people are familiar with your brand and that you own it. Again, you can still use the Circle R and you still get the government protection because your trademark still appears in the database. However, if you are on the supplemental register, your mark is deemed kind of vulnerable because you can never be contestable, like I explained, which means that someone could come and challenge you after 1 year, 3 years, 5 years, 20 years, whatever. So at any point in time, if a third party can show that they had earlier use over you of the mark, like even though they didn't register it, but they were using it before you, and it's something that is very similar to your mark, and they can show that they have those superior rights, they can move to cancel your registration at any time. So just keep those things in mind. So I hope this has been helpful. If you have any questions, please feel free to drop a comment below. You can also email me at Nicole@Creativa, and that's CreativaIP law.com. And I welcome a chance to talk to you more about the trademark process. All right, thanks, and have a great one. And I'm going to stop this and then stop the recording. All right, so happy Tuesday, you all. Bye.